And it's also indicated by my signature under duress on the release. Now, if they want the $30,000 back, we can talk about that too. But if that's what they're basing this
Mr.
on.
Goss, just want to point out another issue. Where in your brief did you elaborate in any degree at all or mention that you signed the release under duress?
In this brief, I didn't. In the previous one, I didn't. I believe also because I did, they brought up that you all did
Where in your
PCA.
brief did, in this
No, in
case,
this one I didn't. I thought I made that
about-
clear. No, in this one it's not.
Well, that we have to go on the briefs and the record in this appeal, and your opposing counsel raised the issue of the release as justifying.
But the release is signed under duress, Your Honor.
Where in your brief did you argue that?
No, I did not in this one. This one is simple. The trial court abuses
We have to
discretion by
follow rules,
release.
just like you're saying, the trial court never has to follow rules. We have to follow rules. We only have the authority.
I understand this, Judge Atkins, and I appreciate if you give me a little variance. No one is disputing, and I'm still within the statute of limitations. So if we're going to argue this other issue, we can do that at another time. And by the way, I did ask this court to reconsider their PCA, given the new set of circumstances and the fact that the trial court had no jurisdiction over the unplayed issues, and they essentially resolved unplayed issues. I did not sue State Farm, Austin Road Basketball, Dr. John Shim Spine of the United States government, which I will now. I only sued Chandra Tucker and Linda Tucker, and she did say something that was correct, for the incident that happened on January 16, 2017. Everything else happened after January 16, 2017. Everything happened after that day. The only thing that happened on January 16, 2017 is that Chandra Tucker, and they filed a notice of negligent admission, intentionally ran her vehicle into the rear of my Kia. That's what happened on January 16, 2017, and I'm saying that because she said it in our deposition. So this is nothing's unclear to me. And I'm a little bit stunned by the fact that attorneys have walked in here and admitted that they conduct themselves this way. Now, I don't want to make this a biblical issue, even though you talk about me, God bless the United States. The Bible says in Luke chapter 11:45, woe unto the lawyers, for they lay men with burdens grievous to be borne. They touch the birds with not one of their fingers. It goes down further and says, woe unto the lawyers, for they take away the key of knowledge, entering not in themselves. For those that try to enter, they hinder. And that was said by someone much greater than me. The Messiah said that. But we're standing in here about this issue. And whether the court does it or not, I just wanted to make sure I had my opportunity to speak to this. And I appreciate them being so candid as to their despicable behavior. And I'll wait for this court to rule not only on this one, but on my request for reconsideration en banc to the last decision and for a written opinion. And I would like to have a written opinion in this case as well to give me an opportunity to hopefully go to the Supreme Court and have them at least address this issue of this kind of behavior, because the privilege issue, the attorney-client privilege cannot prevent the disclosure of communications made in contemplation of a crime or the perpetration of fraud.
Mr. Doss, thank you, sir.
Thank you
You're out
so
of
much.
time.